Hello everybody, welcome to my channel. Today we are discussing about the borrower's remedy. In case if you have not watched my previous video on how the banks will take possession sale of a property, then do watch it in the link that is given above and read about it, learn about it. And then if you are a borrower, what remedy you have when it comes to the bank's section 14 action, that is possession of your property. Now remember, this lecture is for students who are preparing for IBPS SO law officer examination, and also for SBI specialist officer examination. So you have to understand the fact of borrower's remedy. This stems from section 17 application. So the section 17 of the SARFAESI Act allows the borrower to approach the DRT if they are aggrieved by the secured lender's action. Now section 17 is the borrower's remedy that the borrower has to utilize before approaching any higher courts like the High Court or the Supreme Court under the writ jurisdiction. Now, what the DRT can actually examine the SARFAESI action undertaken by the banks, whether it follows the procedure prescribed by the statute, whether there was any violation. Then if it finds a violation, it can strike down the SARFAESI action and restore the possession of the property. Now remember, the DRT can only restore or roll back the SARFAESI action. It can never remove the debts, or it can never fulfill the debts of the borrower. The borrower's debt will always be on the bank's books, which the borrower, no matter what, has to clear it. The only thing is DRT can delay it. And we have to see the important nuances of section 17 and the timeline and recent case laws. So application to DRT, remember, any person, including the borrower, who are aggrieved with the measure of section 13(4) can apply to the DRT. So this is a very important distinction. It says not only the borrower, any person can approach the DRT. Why any person is a significance here is, usually the banks follow equitable mortgage. Remember, in equitable mortgage, an MOTD is done, that is memorandum of title deeds. The borrower deposits the title deeds with the bank, and the bank has the title deeds, but the possession is with the borrower. So the borrower is free to do whatever he wants to do. Although technically in loan agreements, the borrower will be required to inform the bank of the tenancy, and the bank is duty bound to check whether any tenant or whether any leasehold is formulated on the mortgaged property. Neither does this. In my experience, neither the bank nor the borrower inform each other of tenancies. So remember, a tenant can also approach a DRT under section 13(4), because it's not the borrower alone, it's any person who is aggrieved. Because if you have a valid tenancy, valid leasehold, then the tenant can approach the DRT. Now, of course, if the leasehold is made before the loan, then the tenant has much more power to stop the SARFAESI action. But if the tenancy is made after the loan being given, then the tenant's position is little weaker, but not completely zero. The tenant can in fact approach the DRT. The bank will always say that the tenant has failed to do due diligence of an existing charge over the property. But on the other hand, the tenant can also counter argue that the bank had a constructive notice of their presence, because the tenancy would have been existing for quite a period of time, for years. So it is the duty of the bank to visit the mortgage property, the security, and whether the security is being maintained or not under the bank's monitoring policy. So the most important thing that you have to remember is any person aggrieved by the DRT SARFAESI action can approach the DRT. And the important thing that you have to understand is the time limit, the limitation under which the borrower or the person who is aggrieved by the bank's action has to approach the tribunal. It is actually 45 days. 45 days is the days under which the borrower or the person aggrieved has to approach the DRT. Now, remember, it is not an appeal mechanism. The Supreme Court said that it is an original proceeding like a suit, and DRT examines the matter afresh. It's like an original proceeding. It's not like the borrower is appealing the SARFAESI action. Now, which DRT? Jurisdiction of DRT. Now, this is something that is dealt, and the borrower can approach where the cause of action arose. Like anything could happen during the SARFAESI action. They might have failed to publish sale notice properly, or they might have failed to publish the possession notice. They might have failed to publish in proper newspapers. They might have failed to publish in the newspapers circulating in the properties area. There might be actually a flaw in the demand notice. So there are various things. Or during the possession taking process, the advocate commissioner might involve, or the bank might actually do the procedure wrongly. So any DRT where the cause of action arose, or the DRT where the secured asset, that the land or the building is located, or in DRT where the bank branch where the loan account is maintained. In all these DRTs, the cases can be filed. Now, why it matters is because it gives flexibility to the borrower. Like I said, the Act gives complete flexibility for the borrower to approach the DRT, whichever DRT that suits him. And it's very important to understand that the DRT is the designated forum and not any court. So it is not the civil courts or any courts. You have to approach the DRTs to find a solution if the bank's action is unjustified or against the SARFAESI norms and procedure. So what does the DRT examine? The DRT examines the core question of whether the secured creditors measures taken under Section 19 were in accordance with the Act and the rules, and if the measures were unlawful, the DRT can declare the course invalid and even recover the possession and management and give it back to the borrower. Now remember, the DRT can only undo a SARFAESI action. It can't undo the loan agreement. It can't undo the debt the borrower owed to the bank, etc. So when can the borrower can go to the DRT? The borrower cannot rush to the DRT just because the bank has refused the representative section 13.3a. Remember, when the demand notice is issued by the bank for 60 days, the borrower can approach the bank and give a representation, and the bank is duty bound to respond within 15 days. And within those 15 days, if the bank has rejected the borrower's request, just because of such rejection, the borrower cannot go to DRT. The borrower should have any substantive real uh, cause of action or real substantive issue, matters in issue, to approach the DRT, which can be procedural default by the bank not following the SARFAESI procedure, etc. The right to apply under Section 17 arises only after an actual measure under Section 13(4) is taken, that is possession. So only when the possession, or when um, during taking possession, or during sale notice publications, or even sometimes in terms of failure to publish the demand notice properly, uh, the borrower has approached the court. So the reasons and the cost of action should be communicated to the DRT properly under Section 13(4). And just because the borrower didn't like the SARFAESI action, they can never go to the court. The borrower can go to the court only when the bank's action are violating the procedure prescribed by the act. Now, many cases, now this might be the theory, but in practical, the borrower approaches DRT for many issues, and the DRTs have been very magnanimous in accepting the which needs to be changed, because the public money is at stake, and DRT has to be strict with that. And disposal rule, the DRT should make every endeavor to dispose within 60 days, and it can be extended up to 4 months, but this is hardly followed on paper. And DRT has got plenty of backlog cases, which is another curse which needs to be remedied, because India's court system has known for its huge backlog of cases. Now, in the UBI, United Bank of India versus Satyawati Tondon case, it was categorically said that the borrower must exhaust his Section 17 rights of approaching the DRT before bringing a writ jurisdiction under High Court, and the High Court should not unnecessarily intervene with the DRTs. And even a Section 14 possession is to be challenged only under the DRT and not by a writ. Only if the DRT has made error of law in adjudicating the borrower's case, then a writ application is available to the borrower to High Court, and the High Courts are usually advised or recommended to not to entertain DRT matters unnecessarily. However, this is hardly the case. High Courts do entertain DRT matters. A quick recap: Section 17 is any aggrieved person, including including borrower, can approach the DRT within 45 days, and it is not an appeal; it's original proceedings. And the jurisdiction is, it can be either where the cause of action arose or where the asset or branch is located. And DRT checks if Section 13(4) measures were lawful or can, and if it is unlawful, they can restore the possession or the management. And it is very important to exhaust your Section 17 remedies before approaching to the DRT. And please test your knowledge by testing yourself question. And hope you understood today's concept. Tomorrow we will see the appeals process. Like I said, DRT has an appellate procedure that borrower can actually appeal to DRAT and to the writ. So what are the procedures? So we'll look into the appeals procedures. Do share this video for someone who it would be helpful. And if you don't understand what I said, or if you don't understand a particular topic, please type in comments. I will read each and every comments, and I will try and reply to the best of my ability, so that you can understand and you can clear the IBPS or SPBAPO or any legal officer examination, SEBI, etc. All the best. Thank you.